Hello, everyone. This is Cecilia Friedman-Levin. I am CISA's Policy Director, and I hope to be joined shortly by Laura Flores-Bachman, who is our Senior Legal Counsel and is having some technical difficulties connecting to the webinar. But we will go ahead and get started, and she'll be able to join us when she is able. So good afternoon and good morning to you all, and I am extremely excited for this webinar today. And here is what I hope you are able to get out of it. We want to really kind of use this as a virtual kind of table in your office. I have a tea, I have my 8 CFR, and I am ready to go. So how many of you, and you can raise your virtual hands, have a space or a time in your office where you can connect with other practitioners to discuss all of the questions and concerns that are happening in your cases? How many of you already kind of have a real life space like this? And you can raise your virtual hands. Carla, Maggie, Jillian, Vienna, Natalie. Okay, great. So it sounds like this is something that you already do and that you're familiar with, and I hope you find them a valuable space within your own organizations, because it is my favorite time of the week is when we at ASISTA come together to talk about all of the complex issues that we are facing in our technical assistance or issues that we're facing in our policy, and to discuss together what is a strategy, what are our options, how can we try to fit these pieces of a puzzle together, and to do it together. So we could discuss options that Laura and I believe are available, and you might be like, you know what, ASISTA, I would do it different, and I think that's wonderful. And I hope that we're able to use the public chat box today to be able to discuss some of those options and what you would do differently. Another quick note about today's presentation, we have a lot of polls, which seems to be one of the ways that we are able to make these webinar formats more interactive. So we will be throwing a lot of polls at you during the next hour and a half or so. And then also, we have created these slides based upon questions that came in from you. So for those of you who are early registrants, the early registrants get the questions. And so we are based these scenarios and slides based on questions that came in. If we will try to leave some time at the end to answer some questions that you have. But these are things that came in through your registration that we wanted to take some time to address today. So Laura, are you able to join us? I think that we are trying to get everything set up with Laura. But before she's able to connect.
Can you hear me now, Cecilia?
I can.
Yay,
Welcome, Laura.
I'm on. Thank you. Sorry about the technical difficulties on my end, but I'm ready to go.
Right. So this case round today is geared toward those who are filling out survivor-based applications, immigration applications. So for those practitioners who work on VAWA self-petitions and preparing new visas and some of the nuts and bolts of putting those applications together. So why don't we go ahead and get started with something that is always an emerging issue, which is fee waivers. And again, with the materials that you have available is the PowerPoint presentation, but we can follow up with you after today's webinar with any materials that come up during the discussion. Sometimes we like to kind of throw things in the chat box that we think of, oh, there's this memo that we think is really important, or have you thought about this practice advisory? And I think that we wanted to just see what issues came up during the course of today, and we'll be sure to follow you up with those as needed. So let's go into our first scenario. Preparing fee waivers. You have a client, Christine, who's eligible to apply for a U visa. and she hasn't been working since last November. And preparing the U visa, you talk about fee waivers, and she gives you her son's Medicaid card, a bank statement, and her W-2 from her old job, and her 2018 tax forms. And if we could have our first poll, please, Council. What do you submit? Would you just have a sworn declaration? I like that. I think that it meant to be a sworn declaration outlining her income and expenses and why she's unable to pay. Would you just submit the copy of the Medicaid card and her most recent W-2? Would you kitchen sink it? Would you have the fee waiver form with the Medicaid card, with the recent W-2, with the last tax return, with a declaration from her and a declaration from her counselor and a declaration from anybody else who could possibly write one? Would you do something else? And those of you who did something else, I'd be very curious if you could put in the chat box what that something else is. So we would give folks another moment to say how they would, what types of documents they would submit with their fee waiver request. All right. So Leah would just do the 912 and just the tax return from 2018. Okay, and Nicole would do tax returns in the 912. All right, can we close the poll, please? Okay. Oh, so it's saying about 77% of you would kitchen sink it. And Laura, would you kitchen sink it too?
You know, in this day and age, I'm afraid I probably would. I'm usually a proponent of not wanting to raise the evidentiary bar on ourselves, you know, by giving more than what is required by the policy and regulations. But at the moment, you know, client comes first. We need to get those fee waivers approved.
Right, and so I've had a case recently where I submitted a fee waiver with just proof of receipt of a means-tested benefit. And then it came back and it said I need more information. And so then I had the bank statements and a letter from her counselor and a letter from her kind of outlining the income and expenses and kind of what her rent is and other things, because I think that it's important to demonstrate the eligibility for the fee waiver. I want to just take a minute because there's been a lot of back and forth on fee waivers and there's been a lot of potential changes coming down the road. So I just want to take a moment to let folks know where we are. I got to note that my volume is low, so if you can hear me, if you're having trouble hearing me, please let me know. So the fee waiver guidance is from 2011, is still in effect. And that guidance outlines 3 criteria for fee waivers. One is receipt of a means-tested benefit. 2 is that you are at or below 150% of the federal poverty guidelines. And the 3rd is that you can demonstrate a financial hardship. There have been other policy proposals that are still pending that might change those. But for the moment, there are 3 criteria that you can submit your fee waivers based on any of those 3 criteria outlined in the 2011 guidance. Furthermore, it says that USCIS would still accept what they call applicant-generated fee waiver requests, which are those declarations that we practitioners would submit that outline, this is my income, these are my expenses, and this is why I'm unable to pay the fees. So even though technically they should be still accepting those applicant-generated fee waiver requests, I think that both Laura and I would say that as a best practice, it's important to probably utilize that 912 fee waiver form, which kind of discusses the different criteria and information that they are looking for under those 3 stated criteria. We will keep you posted about if and when that is going to change, but fee waiver policy as it is today, and if you go to the USCIS website under 912, which I encourage you to do for another reason, to make sure that you understand which policy is in effect. Laura, do you want to go through why they should check out that website, or do you want me to?
Well, yes. Actually, why don't I just go through it real quickly? I don't know if you guys have had the opportunity to look at our most recent practice alert, which was actually just about an hour ago. And our recent practice alert actually refers to the USCIS forms. As of yesterday, USCIS announced that there are new additions for many of its forms, including many forms that we use in our humanitarian-based cases. And the reason for the switch or the newer edition of the forms is their implementation of the public charge rule. And so what's important to note is that if your forms I-485, if you're using forms I-485, I-864, I-539, or the I-912, our fee waiver form, if you're using any one of those forms and your packet to USCIS is postmarked on or after February 24th, then you do have to be using the new edition of those forms. And so although the public charge rule, as you guys know, does not apply to VAWAs, U petitioners, and T petitioners, you still have to use the updated form. I will say it's very important, do not submit the new I-944 public charge form, right? So since VAWAs, U's, and T's are exempt from the public charge rule, there's no need to submit that form. But do check very carefully that you are using the right version or the right edition of the form. And honestly, the best way to do that is go to the USCIS forms website. So again, that's any forms that are postmarked on or after February 24th, including the fee waiver form.
Great.
Oh.
Thank you, Laura. And so again, please do check out those websites. They are always constantly changing. So this is a really important update, especially as you're preparing your cases. And on the website, they have what they call a proposed form, which I believe is the newer version of the fee waiver forms. And so those are already on there. So we definitely encourage you to check it out. One other thing I want to say about fee waivers, what if you have multiple grounds? What if you are eligible for a fee waiver or believe that you're eligible for a fee waiver on more than one criteria? Do you just choose one, or do you think you choose as many as apply? What do folks think? You can put it in the chat box. What has been your experience? Yep. So Sally says pick the easiest one to prove. Deepa and Nicole, Allison saying that you are able just to choose everything that applies, and I think that that is true. I think there's been some back and forth whether or not this would make things more confusing for USCIS to choose more than one grounds or criteria. But then I think you either pick your strongest or you pick the ones that you have the documentation to back it up. And so I think that's why it's important to go back and take a look at You know, maybe her son's Medicaid card can't be used to show receipt of her own means-tested benefits, but it could be used potentially to show financial hardship or 150% below the federal poverty guidelines, whereas means-tested benefit refers to the receipt of the means-tested benefit by the applicant or the head of household. Right, and so Judy asked whether or not the means-tested benefit will still qualify for, I think this is a public charge question that we are getting from Judy about whether the means-tested benefit will still apply for VAWA after the new rules in effect. The public charge grounds of inadmissibility does not apply to VAWA U and T visa cases. And so that said, that there are resources that our partners at the Asian Pacific Institute on Gender-Based Violence. There's actually a webinar after this one if you want to make a webinar afternoon specifically on this. And so we will be, definitely there's going to be information out to the field about the impact of the public charge rule. But the grounds of inadmissibility for the VAWAs, U's, and T's will not apply to these survivor-based protections.
Cecilia, just one quick question. Maybe you could clarify the proposed fee waiver changes, the proposed fee waiver policy. That is not in effect, correct?
No. So as of right now, if you're applying for a fee waiver, you can use all three criteria from the 2011 fee waiver guidance. Means-tested benefits, 150% of the federal poverty guidelines, or financial hardship. This might change pursuant to other policies that are in effect and in the pipeline, other proposed rules, other proposed form changes, but those form changes have been the form changes have been enjoined, and so as of now, as of today, and at least until maybe the end of May, that the three criteria for fee waivers that are contained in the 2011 guidance will still be in effect.
Okay, great. Thank you for that clarification.
Why don't we move on, because this is only the first slide and we're in 20 minutes, but I think it's important to spend some time on because fee waivers are important. It is a gatekeeping form. And I think it is extremely important to take some time to think about not only one, acknowledging the different challenges that survivors and you as their advocates are facing, improving them, but especially because we're seeing scenarios like this next one, where you file a U visa adjustment with a fee waiver that was filed 2 weeks before your client's U visa expired. You receive the denial of the fee waiver from USCIS a week after the visa's expiration. And if we could have the poll. What would you do?
Okay, so what are your options? Would you file an I-539 and refile the I-485 with the fee or the new fee waiver? Would you file an I-290B motion to reopen with a new fee or a fee waiver? Or would you file an I-539 first, get that receipt number so you have an extension of the U pending, and then refile the I-485? Or do you have no idea what we're talking about? Oh, I'm sorry, I'm looking at different options here, sorry.
I don't know if this is the right one.
Yeah, this is not the right poll. So let's close up that poll, and we'll actually get back to that poll in a minute. But let's just go to the next slide because maybe it didn't pull up as a poll. Yeah, so let's just talk about this then. Okay. So again, your options are file the I-539 and refile the 485 with a fee or a new fee waiver. Would you file the I-290B motion to reopen with a new fee or fee waiver? Would you file the I-539 first, get it receipted, then file the 485? Or you're not sure? Okay, and I'll give people just a couple of minutes since we had that mix up with the options. And what I'll do is if you could just answer in the chat box instead, since we don't have it set up as a poll, that would be great. Okay, so as people continue to include their comments or their case suggestions, here's what we have to work with, right? So we have a U petitioner who, or actually a U visa holder or status holder who's eligible for adjustment, files for adjustment, and now they've gotten a kickback, right? And their U visa has expired. And the reason that's important, which all of you know, and this is just a review, is that the U visa has to be valid at the time that the adjustment of status is filed. And then the U status is automatically extended by that timely filing. So that's why this is so important. That's why getting a fee waiver kickback and not getting the I-485 properly filed gets us into a whole bunch of issues. So let's see if we have anyone here who would file the I-539. Okay, so Allison would file the I-539 with the 485, with the fee, or with the new fee waiver, just depending on the circumstances, I suppose. Now, one thing I will say is if you file the I-539, it's late filed, right? So what does that mean? What do we have to do if our I-539 is being filed after the U has already expired? Well, a couple of things. One is that we need to show good cause for why it wasn't timely filed, so that it was outside the control of the U petitioner of why it wasn't filed on time. So obviously you're going to include information about the efforts made to file on time through the filing of the I-485. Had it been properly receipted, the U would have been automatically extended. So showing the efforts that you made, but that it was kicked back. So that's one thing. Make sure that you acknowledge that it's being filed late, but that this should be excused. The second thing that you're going to want to ask for is that when the I-539 is approved, that it's approved back to the date that the U expired, right? So you want to basically put your U petitioner back in the same place that they would have been had the fee waiver been approved. And the beauty of doing that is if you can get your U extension back to the date of when it expired, and you file your new application for adjustment of status, the I-485, at the same time, concurrently with it, then if the I-539 is approved, the 485 that you've submitted with it is properly filed at the time of filing, because it's as if the U never expired, right? Because the extension is back to the date of expiration. So that's really important, is that you're not just asking for them to extend it, you're actually asking them to extend it and to approve the extension back to the date that the U expired, so that there is no gap in status. And that will ensure that your I-485 will be properly filed. Okay, so what about you, Cecilia? Any other suggestions on this?
No, I think that covers it, but it does sound like this has happened to a few of you. And so kind of providing that coverage, and I think that is not on the slide, but asking for that non-pro-tunc kind of retroactive application is a really important part of that, to make sure that
yes,
your client is still in status.
Yeah, and one thing I will point out is the October 2016 U visa extension memo. So there's a policy memo from October of 2016 that talks about U visa extensions and T visa extensions. And there in that memo, and we will add it to your materials after this, now that we see that this is coming up for a lot of you. There is reason for asking for an extension beyond the 4 years as well, because I know that's one of everybody's concerns as well, is that now you're asking for an extension, you're asking for it late, you're asking for it to be non-protunct, but in addition, you're asking for the extension beyond the 4 years, and there has to be reason for that as well. So look at that memo, because I think it helps you in showing that as long as you show that there's a reason for needing the extension, that it's an exceptional circumstance for needing the extension, they can approve your U visa beyond the 4 years. So that extension memo is helpful with language about that. The reason I bring that up is because I know many people, well, I shouldn't say many, we have had situations where USCIS will try to apply the rules for non-immigrant visa extensions that normally apply to other non-immigrant visas. They'll try to apply those to U visa holders. And so we have to make sure to make our arguments in accordance with the U visa regulations at 8 CFR 214.14, but also in accordance with their policy memo that's specific to U visa extensions, so that they don't try to apply a different standard. Okay, so let's go ahead and move on.
Right, so Kelly has a question, a procedural question about, do you file the 539 and 485 together? Like, what is the best practice? And I think that I've seen people do it a few ways. Sometimes people file the 539 first, get that receipted in, and then put that receipt notice with the 485. But I think this is just a different practice pointer. What's your experience, Laura?
Well, and so that's the assessment that you're making, right? I've seen it done both ways. Some like to err on the side of caution and first get the U extended, right? And there's a couple of reasons why an attorney would be doing that. And the reason, the biggest reason for many clients is money, right? If they're not qualified for a fee waiver, or they don't want to risk it, right? And they just want to go ahead and file with a fee, and you're filing both forms, the I-539 and the I-485, then the risk that your client is taking is that if the I-539 is denied, then their I-485 will be denied as well. Therefore, they'll be losing those filing fees. And that's a big deal considering how much filing fees are for both of those forms, right? That's one way to look at it. The second way that attorneys look at it is say, well, if I don't file the I-485, my client won't have work authorization. And that's a big issue for people. So, and then the second part to that assessment is the fact that they have to take the risk, right? Either way, they have to file the I-539 to get the U extended and file the I-485 to get that work authorization. And the client may be willing to take that risk because either way, they have to file the I-539. They may as well have work authorization while they're waiting. So bottom line is, it's obviously case specific to your client, to your client's circumstances, and to their ability to pay. Now, one of the things we haven't talked about underlying all of this is, while you're doing while you're taking these steps, these practical steps, dealing with, status, which is the most important thing, what else can you be doing? Do you do some advocacy? And the answer is yes. And so for those case specific situations, we do urge you to contact us through our technical assistance. And we can certainly help you in advocating. For example, if that fee waiver should have been approved, let's see if we can point this out to Vermont Service Center to show just how egregious, the kickback may have been, depending on the client's circumstances. If there was, in fact, an error made on their side, right? If there was sufficient evidence, there may be some advocacy that we can work on together.
Okay, thank you. So as a recap, we have the changes, potential changes to the 912 fee waiver form. They are not yet in effect. The 2011 fee waiver guidance still applies, and that USCIS must accept applicant-generated fee waivers, consider all three criteria, and have one 912 per family unit. I think that we covered that. And that if there are any changes or any developments, we will for sure let you know. And so our practice pointers just documented. I think that the 77% of you that decided to kitchen sink it are on the right path. Provide a clear roadmap and index. I have submitted a separate index just for supporting documents of my fee waiver request. Kind of having, this is what it is, this is A, this is B, this is C. That is just for the index for the fee waiver, so that there's all kind of the information that's needed to make that determination. And get it in early. I mean, you don't want to be in a situation where you are gambling away a deadline. If that is a 290B or if that is a adjustment application, to avoid any problems with kickbacks by getting applications in as early as you're able. Now we're going to turn to your VAWA questions. And so now I think that, Laura, you're going to start us off here?
Yeah, let's start with another case scenario. So Luisa filed a one-step application with her spouse, Taylor. Luisa later flees the house with her two children after Taylor was abusive to her and was abusive to the children. She later meets with you and files a VAWA self-petition. You ask the local USCIS district office to hold the underlying I-485 in abeyance, and they refuse. If we can go to the next poll, please, and have that pulled up. Okay, so what are your options here? Do you refile another I-485 for Luisa based on the I-360? Do you send a letter asking for the adjustment interview to be rescheduled, invoking 8 USC 1367 protections? Do you take it up the chain of command at the district office? Do you contact your ombudsman through an inquiry or a case assistance request? Or do you contact ASISTA and ask for our liaison assistance? Or do you have some other thing that has worked for you?
Right, and that might be some combination of these. So if you do have other, welcome to you know what that is.
Yes, absolutely. Put it in the chat box, please, if you select other. Okay, and I think we will close out our poll. And so let's see, 35% of you would absolutely contact your ombudsman, the DHS ombudsman through case assistance request, and would contact ASISTA. And then let's see, the next most popular option was refile, right? Sometimes you just don't have the ability, clients don't have the luxury of waiting to see if USCIS will keep the I-485 alive. You obviously want to keep the client under color of law, in other words, present in the US and not subject to removal proceedings, and also, of course, able to get work authorization. So you don't, sometimes you just don't want to take that risk. Send a letter asking for another interview. That was 14% of you. And then let's look at our others. Let's see. Yesenia mentioned wait for the I-360 to be approved and then file the 485. And so that might be an option as well. I think the risk that you're taking there in some instances is that if the original I-485 filed by the abuser is denied, then it puts your client at risk of getting the issuance of an NTA. Additionally, you run the risk of that initial I-485 being denied because of the abuser submitting a letter to withdraw his I-130 for Lisa, right? And so once he withdraws that I-130, USCIS is going to deny that I-485 based on that withdrawal. And since you won't know the timing of it, sometimes there is a risk. However, I will say we don't have the fact in this scenario, but assuming that Taylor is a US citizen, then it may be that instead of having to wait for the I-360, you could just go ahead and file the I-485 now. But Yesenia's right. Otherwise, if Taylor's an LPR, you would have to wait for the I-360 to be approved unless the priority date is current now. So those are all things to consider. Sally mentions that if it's already denied, so I'm assuming the 485 is already denied, you file the 485 so that she continues to work, but otherwise contact folks to complain. Yes, do it all, right? And let's see. Elizabeth has a question on the best number to call for individual case assistance. And if it's for our individual case assistance, it would actually be through our TA request form, the OVW TA request form on the ASISTAHelp.org website. And then once you are assigned to one of the attorneys on staff, either myself or Cecilia or Amy, then you can talk to us about the best way to set up just a conversation on your case assistance. And then someone mentioned doing a combination. Yeah, that's absolutely right, right? So advocacy can always be something that you do, right, at the same time that you're looking at the risk factors in your client's case, right? So at the same time that you're looking whether or not to file an I-485 or go with abeyance, you can always at the same time advocate. Contact us for liaison assistance, contact the Ombudsman's office through their case request inquiry form. We can do both. The problem is that while we're doing advocacy, it doesn't slow down what's happening substantively in your client's case. So always look at the risk of whether filing the I-485 is necessary to keep your client in some kind of quasi-status and not get an NTA issuance. The other thing I will mention, here's USCIS's position. So USCIS policy is that if the I-130 has already been denied before you get your I-360 filed and before you make your request, well, actually just before you get the I-360 filed, then their position is that they can't hold something in abeyance because there's nothing they can't transfer the I-485 because there's no basis to transfer it on, right? So in other words, it's really important to have your I-360 filed as soon as possible so that it is filed before the I-130 denial comes through, right? And since we don't know how quickly the abuser is going to move to do that or whether the abuser is going to move to do that, filing that I-360 first is just the most important thing to do, and then get with the local office and make your abeyance request, because without having the I-360 actually filed, making a request for an abeyance based on the fact that you are in the future going to file the I-360, unfortunately, right now, that's just not enough. We know that some local offices are still, pretty helpful to victims and will, just hold it based on your word, but that's few and far between these days. They really are wanting for you to have that filed.
So there's a really good question that has come up, and
okay,
the question is, to invoke 8 USC 1367 protections, Does the I-360 have to be filed already? And so what I'm going to put now in the chat box, and again, this is going to be not just in the chat box, but we're going to follow up with you in a very nice, pretty, is that the guidance, at least for non-disclosure, kicks in as soon as a DHS employee has a reason to believe that the individual might be a beneficiary of a pending or approved application or petition. So that is for the non-disclosure, right? For the adverse action part of the statute, so for those of you who are like, what are you talking about? Why are you talking in code? It's too early or it's too late for me to be doing this. The part of the law that we're discussing there is 8 USC 1367, is where it contained very important confidentiality protections that regard to how DHS and DOJ and Department of State are supposed to treat survivor information. And so part of this is about non-disclosure of confidential information of survivors. And the other part of this relates to that, in general, that USCIS or any DHS or state or Department of Justice, so that includes immigration judges, should not make adverse actions in a survivor's case based solely upon information provided by the abuser or a member of the abuser's household. And that adverse action section applies, doesn't necessarily mean that there's a pending or approved VAWA self-petition. It could be while someone is in the process of applying for relief. So I invite you to kind of take a look at that guidance, and that has definitely more details about when these provisions would kick in. So now we're going to go ahead, because you're asking such wonderful questions and we are so much ground to cover, that we are going to go ahead and move on. This next question is very similar to the next one, and so I'm just going to read the scenario. Victoria is the beneficiary of an approved family petition based on a marriage to a United States citizen. So the I-130 is approved. She later files an application for adjustment and a 601 for misrepresentation, which was denied. She now files a 290B, which is still pending, but you are subsequently retained for her VAWA case and are planning on filing the I-360 as soon as possible. Again, these are ripped from the pages of your very own cases. So what do you do about the pending 290B? So this is oftentimes what happens is that we either inherit cases, or there might be a case that has already gone down a family-based petition route, and so now we're switching gears to a survivor-based protection. So we have this 290B that is pending on the old 601 waiver, and now you want to file a VAWA. This question threw me for a loop, and I loved it. So why don't we go to our options? Do you put your G28 on the 290B and just supplement the existing filing with your information about VAWA? Would you refile a new adjustment application and a new waiver? Would you do both and see what sticks to the wall? Or would you do something else? So let's just put this A, B, C, or D. A is just put your new notice of appearance on the old application, just figure out what's going on. Would you refile a new 485 and 601? B, C, do both? Or D, would you be like, I'm going to do something else. I'm going to have Laura handle this, and I'm just going to go out to lunch, which is probably what I would do. But so we're seeing some Ds. Kelly, you have to tell me what your D is. C, A, C, C if possible. And this is good. This is complex. And this is really what I sort of live for. So again, I own my nerdiness. It's totally fine. So I think we need to think this through. Number one, what could withdrawing the 290B lead to, right? If we were to say, like, no, we want to scratch this, we don't want this happening, we want to put all of our eggs in our in our VAWA basket. If we just let this go or we withdraw it, I think that there is a concern that that could lead to a notice to appear and having our client be put in removal proceedings, right? So we don't want to just simply ignore it and wish it would go away. I think that ultimately we need to put on our G28 on the application and saying that we are filing for VAWA. If you have an I-360 receipt notice, you can include that, and just saying that there is another supplemental application that is pending. USCIS, according to teleconference notes that it issued, said that if their applicant has other good faith applications pending, that they will keep that in mind before they issue an NTA, but that nothing would preclude them from doing this. So I think that what your first line is kind of to let people know that there is another good faith application on the way. The other, and so I think also I would make sure that I invoke the confidentiality provisions as well, saying, listen, I am now representing them, we are planning on filing VAWA, and then I would ask the AAO or whoever it was sent to maintain that confidentiality. And so then it depends on timing, right? So in this scenario, we go back. We're planning on filing an I-360, so we don't have one filed yet. And so we have to think realistically the fact that right now VAWA applications are pending 53 to 54, no, I'm sorry, that they're pending, what, over 2 years, I think it is, Laura?
Yes, currently, approximately, right? Sometimes a little longer, sometimes a little bit less.
Right. So I think that is, between 18 and 24 months, I think, is what it is. So it might be a minute before your I-360 is adjudicated. And so that kind of says to me, well, if it's going to be a while of that, to file a new one-step application with a 601 for benefits of getting work authorization, right now, so VAWA applications is taking 18 and a half to 23 and a half months. So in that time, your client might need work authorization, right? And so, but then you also have to kind of think through those scenarios as well and kind of what might be happening in the meantime. And then, so I think that's why I think I would also kind of be in the C route. And because I think at the timing and other options. Laura, do you have more on this? This one kind of threw me for a loop. This one was a sticky one for me.
Yeah, it's a little bit complicated, but I like it, just like you did. I wanted to sink my teeth into this one. So a couple of things that popped up immediately, right? First, what we were talking about as far as confidentiality. So I liked the option to go ahead and submit your G28 and then supplement, telling them, you have this VAWA case. Why? So that, again, your VAWA confidentiality kicks in and the don't take any adverse action kicks in, right? Or at least you have them on notice, and they will be subject to liability if for not maintaining confidentiality, right? Because there's still that risk. So that's the first thing, is I do like that. And the second reason is and now this one you have to just stay with me, right? If your I-290B is still pending, can you substitute a new the I-360 in the place of the I-130 for that I-485 that's on appeal? Now this is, I think this is a little bit tricky in that your I-485 technically, I would argue, is still pending if the I-290B was filed as an appeal, right? Because there's not a final decision on it until the appeal is decided. On the other hand, if your I-290B was filed as a motion to reopen, then there's the argument that that I-485 is closed until such time as it's reopened, right? So you're not able to necessarily substitute in. But it was just one of those things that I would look into, depending on the case circumstances, and see if we could substitute that way, get a work authorization to continue while that appeal is pending. But again, there's a difference between appeal and motion to reopen, so it depends on your case. The second thing is, refile a new I-45 with the I-61. That's possibly the cleaner way to go, because number one, you'll have something, you'll have your I-45 adjustment of status pending and hopefully avert an NTA in the event that the I-290B is denied. And you'll probably also have a better basis for that I-601 if there are inadmissibility grounds where a VAWA exception or a VAWA waiver would be applicable, and perhaps have a better result on that I-601. And doing both, it again depends on the timing. Depends on what you have available, how quickly you have your I-45 and I-601, a new I-45 and I-601 ready to go, the ability of your client to pay or submit a filing fee quickly with documentation. So those are just things that kind of popped into my mind about what I would do and why I would do it. Let's see, do we have questions based on what I have said? Okay, so one of the questions from Deepa is, if a motion to reopen and the I-45 is still considered open, how can you file another I-45? So technically, if it's an I-290B motion to reconsider, the I-45 is not technically still open until the motion to reconsider is approved. So you could file another I-45. And then let's see, I think filing an entire one-step package would be safer, and that's from Maria. And correct, yeah, for the reasons I just stated a couple minutes ago, it might be safer, right? You're not risking anything, that the abuser will beat her to the punch. Oh gosh, sorry, I did not mean to use that. I apologize. You're not risking that the abuser will withdraw his approved I-130 while the I-45 601 is on appeal. So rather than risk it, filing the entire one step might be a safer bet and might be something that your client prefers, particularly if they have the ability to pay the filing fee, or if you have a well-documented fee waiver. Another question from Yesenia, what is the potential client? Wait, what if, I guess maybe if, what if the potential client files one-step AOS as a minor without illegal entry? Okay, this seems like a different version. Yeah, that's a different version on the case, but I think we have to move forward. But Yesenia, I would love to answer your question offline if you want to either email me or submit it as a TA. I'd be happy to talk about it.
All right, I can read this for you, Laura, if you like.
Yeah, let's do it.
We have Joy, who is married to Philip, a U.S. citizen for 2.5 years, and they have an 8-month-old child together. He's constantly calling names, insulting her, including in front of his friends and family. He grabs her phone away if he sees her trying to call or text friends, calling them a bad influence. He doesn't let Joy have access to any of the bank accounts and treats her like a servant in the home, often saying that she doesn't have to, if she doesn't do all the cooking and cleaning, he could always call ICE to have her deported, and that she would never see their baby again.
Ugh.
Is Joy VAWA eligible? I think we have our poll. Yes? No? Are you unsure?
Okay, I am so happy to see these these results as they're coming in. Let's give it just a couple more seconds. Okay, let's close it out.
Right, and I think this is a good question because
right.
I think oftentimes that, cases that are based on emotional abuse, I think that there, I think there's different considerations in terms of what you're putting in your application. So Laura, I'll let you take it from here.
Yeah, so let's go to the next slide. I think the biggest thing that we have to look at here is probably making sure that in our application, we are not assuming that the adjudicator will be completely trained on extreme cruelty. If our case is based on this extreme cruelty that your client has suffered and it's primarily emotional abuse, then I think what you're going to want to do is ensure that the evidence that you are submitting and the arguments that you're making fall in line with this, right? So there's a Ninth Circuit case that Hernandez v. Ashcroft, where basically the Ninth Circuit Court went back to the USCIS regulations on extreme cruelty and said non-physical actions can rise to the level of domestic violence, which we all know they're preaching to the choir, but it's good that we have a court actually spelling that out. And not only do they spell it out, they refer back to the agency's own, to USCIS's own uh, interpretations of it, right? So we have to make sure and make those arguments, make sure that we don't assume that just because our client's declaration includes a lot of information about the extreme cruelty that she suffered, we can't assume that USCIS will make, connect all the dots. So let's connect all the dots for them. We'll argue that the non-physical actions do rise to the level of domestic violence because they were tactics of control and they were intertwined with threats of harm in order to maintain that dominance through fear, right? And so, so having, perhaps your client explain exactly what it was and that it did rise to that level, that it's not just that the abuser was that it was perhaps an unhealthy relationship, or that the abuser was just quote unquote being mean, but really that the abusive actions, although may not have been initially violent, when you take it as a whole, when you look at the overall pattern, it is a pattern of violence. So I think it's really important that we kind of spell it out for them and also spell it out in our evidence. When you're putting together your evidence on an extreme cruelty case, I always like including a detailed index, and you can say, Exhibit A is this text message, right, from the abuser. What are you showing by it? So I will just spell it out for them. Exhibit A, text message, date, time, from and to, and then I'll just put what it shows. This text message shows, together with exhibits B, C, and D, that the actions by the abuser do rise to the level of extreme cruelty because it's part of a pattern of violence. Spell it out for them, go ahead and connect the dots. I think it's so important. And of course, refer back to the regulation, because oftentimes it's really nice to be able to just cite to their own regulation and show how you're meeting that regulation. So what types of evidence, right? We talked a little bit about you're going to have your client's declaration, maybe horrible text messages. What else can we use to prove extreme cruelty? And please, again, go ahead and use your chat box. Give us some examples. If you have had a case where there was no physical violence, but there was substantial, evidence of the extreme cruelty. Well, I shouldn't even say substantial. That's not the standard. But there was evidence of the extreme cruelty. Then let's talk about what would you submit. So you have your client has therapist or counselor letter or other supporting affidavits, maybe witnesses who, who can testify to the actions of the abuser and why they felt it rises to that level, particularly if you're talking about a therapist or counselor whose area of expertise or whose practice area includes domestic violence victims, if they can talk about not only what your client told them has occurred, but also if they can include why, in their opinion, this is domestic violence. That's also helpful. Have the therapist connect those dots. Credibility is important, right? It's important for the self-petitioner to establish her own credibility, but also remember that in all the corroborating evidence, that has to be credible as well. So just, some general standard guidelines when we're talking about affidavits of others, make sure it includes, if you're talking about a therapist or counselor, it's on organizational letterhead, it has their full title, maybe just a paragraph about, if they don't have a full CV, just a paragraph about their qualifications, how often they met with your client, like what's the basis of their assessment, if that's what that counselor's letter or affidavit includes.
Right.
If it's, just really quickly, if it's supporting affidavits from someone else other than a therapist or counselor, then just make sure to include, again, maybe just a paragraph or a couple of sentences about how they know your client, how long they've known your client, and why they would have information about the extreme cruelty. In other words, we hung out every day or we worked together. What was the set up the case? Okay, sorry, Cecilia, you were going to say?
No, I said that we, in terms of other materials that we're going to be following up with, we do have these affidavit guidelines, which would be happy to send you, which has those kind of bulleted points, kind of what is the therapist or counselor's experience working with survivors, and not only that, but kind of how often they met with the client and how what the client told them is credible given their experience and expertise working with survivors. And so I think making sure, kind of linking back to that credibility piece, is linking their experience and expertise to what the survivor told them and how, based on their experience, it is credible. So I think that is a really important way, and we can send you those guidelines as we follow up.
Yes, thank you. And I think you'll find the sample very useful. And before we move to the next slide really quickly, I just wanted to point out Yesenia's comment. I think these are good examples that I had not mentioned, so I'm just going to mention them. Providing the criminal history of the abuser, if he has a criminal history that shows his violent nature. Pictures, she submitted pictures of broken glass, plates, or wall punches. So even though the physical violence wasn't on the victim, if those words, and the emotional abuse is paired with punching the wall, just showing his force, then obviously that shows that pattern. And then text messages, make sure to have a translation. That's a great practice pointer. Thank you, Yesenia. So I just wanted to point that out because I thought these were some good examples. Okay, now we can move on to our next area, which is consular processing. And is that still mine? I think it is. Okay, so let's move on. We also had questions on issues with consular processing. Your clients are VAWA derivatives and are being delayed in visa processing because the embassy keeps asking for an I-864, which is obviously not required. It should be an I-864W for self-petitioners. And despite pointing out the FAM guidance to them, they're still holding them up. So what are your options? I don't think we have a poll for this. I think we're just going through these questions. And if you could respond in the box, that would be great. So ask for supervisory review, follow up with the consulate, congressional liaison, and legal net inquiry. Those are all options. This is not a trick question. Those are all options, but what I would like to know is what has been helpful for you? Have you tried any of these? So yeah, sometimes it's going to depend on the embassy, right? Whether you're going to be able to get supervisory review or even connect with the consulate directly. Always start by looking at the specific embassy or consulate's website. They usually have on there the ways to contact the consulate. Those are usually updated. Unfortunately, I already know that some of you are probably going to be typing, they don't even have that. Yeah, there are, unfortunately, some embassies that may not contain specific contact information for immigrant visa processing. It's just maybe just another link to another website. So if you get to that point, absolutely contact your congressional liaison. There should be a manner to be able to contact the embassy or contact the consular office that's responsible for immigrant visas, especially where there's a clear error of clear error of law, policy, and regulations, right? All of it. So I think getting congressional help would be very important because usually they just have a more direct line of communication and will at least get a response and hopefully a contact information where you can proceed. And then LegalNet. So LegalNet is an inquiry system where attorneys or legal representatives can submit a question to the Department of State visa office and hopefully get a response. Unfortunately, it's usually not a very quick response, which is why we actually have them kind of set in order of priority. You'll want to make that direct contact with the supervisor first, then follow up with the consulate, then congressional liaison, then LegalNet. And even though LegalNet can be very, very useful, unfortunately, because their timeline, they get so many inquiries, it may just not be fast enough. So for all of you who said all of the above, I agree with you completely. Take all of these options. If you need assistance, you can reach out to us through our technical assistance line. Okay. Cecilia, did you have anything to add on that before we move on?
I do not. So we are going to move on now to intersections with other forms of relief. If we're in a situation which is sort of, I don't know, like a unicorn situation, which you do have an individual who is eligible for multiple forms of relief, how do they intersect? What does it look like? And so we're going to talk a little bit about some considerations when we're talking about filing, but also some problems that might come up because of these different intersections. We have Javier, who's 15 years old and was seriously physically assaulted in the United States by his father. He and his mother, Zenora, were helpful in the investigation and prosecution, which resulted in a conviction against his dad. We have a minor and mom who participated in an investigation and prosecution against the perpetrator. How would you file these cases? Would you have Zenora as the principal U visa applicant and Javier as a derivative? Would you have Javi as the principal and Zenora as the derivative? Would you have Zenora apply for a U visa, but maybe Javier file for special immigrant juvenile status? Would you have Javier apply for SIJS only? Or would you do something else? And maybe something else is a combination of these. We'll give folks a minute.
Okay, so Sally says apply as principal use and child apply for SIJS.
Right, that is an option, right? And I think that you might have cases in which a child is eligible for special immigrant juvenile status as being the abused, abandoned, neglected child by, it's either one or both parents. So we know that there's physical abuse by his father in this situation, and we have to kind of assess what other kind of family court matter or is in place to see whether or not that is potentially eligible for the special immigrant juvenile status. And so it seems like we have a lot of different options. And I think one consideration is what Yesenia just broke up, is that in some states you can't do SIJS if there's a one parent. And so kind of what is the situation like in your jurisdiction? And also kind of thinking about what the status is about one parent SIJS and where you are located, because many of this would be jurisdiction specific. But also both of them could potentially qualify on their own as principal applicants, as they were both helpful. They can be both considered to be victims. And so, or you can just do it simply. Rachel makes the point that if both of them are U1, and Zora as an indirect principal would be arguing Javier's incompetence, which goes against filing as a U1 as well, right? And so I think that's showing how maybe Zenora could be independently eligible based on domestic violence that she experienced at the hands of the father, right? Maybe there's another own underlying crime that is not a part of his, right? But we know that it could also streamline it. 65% of you just said that Javi's going to be the principal and mom is going to be the derivative, because that way you don't kind of run into issues in terms of defining indirect victim or kind of how mom was involved. So I think there's multiple ways that you can cut it, right? And I think that Deepa mentions that she wouldn't file for a child as a derivative because if mom has inadmissibility issues and is denied, then he'll be denied. So I think all of you are doing a really good job of identifying some of the different concerns that would impact how you might file and frame this case, depending on kind of what is available in your jurisdiction in terms of SIJS and kind of what trends we're seeing in the SIJS adjudication process, but also what does mom's inadmissibility look like? Would that impact having her be the principal and somehow minimizing Javier's ability to establish relief, having Javier be the principal and Zenora be the principal? They each would assess their own inadmissibility issues in their own application, right? So you avoid any kind of person being dependent on the other. Or is it more straightforward to do the child as the principal and mom simply because based on the relationship to Javi just be a derivative and then have her inadmissibility issues just established as a derivative? So I think, again, there's different ways to cut it. I think that Javi as the principal and Zenora as a derivative is probably the most straightforward. But then again, having an SIJS case, if it is available and you're comfortable going forward, could be access to potentially, depending on where Javier is from, of a quicker way to gain status. So I think we have to look at timing. We have to look at inadmissibility issues. We have to look at other different factors that might impact how we decide to file this case.
And so that actually brings me up to, actually I have had this scenario where even though it's pretty straightforward that the child file for a U1 with the parent as the derivative and then go for SIJS as well. One of the things that you run into is SIJS adjustment goes through first because U visas are pending for so long. It's another thing to keep in mind it's certainly something to discuss with your clients at length so that they are aware of the risks. If it gets to that point where it's possible for the child to go forward with I-45 based on an approved I-360 and you still don't have a decision on the U. One of the other final things that was suggested is, what about doing all of it, right? So having Javier as the principal with mom as a derivative, and also mom as the principal with Javier as the derivative, and also 2 separate applications. Well, I don't know that you want to do all of it, right? But do know that there's nothing necessarily restricting seeking all forms of potential relief. So, eventually you're going to have to go forward with one. But at the time of filing, particularly if you can get the LEA certifications for both to be principal applicants, that may be another option. So the bottom line is, of course, assess your funds.
Right, and Kelly makes the excellent point that mom can't get status through Javier if the SIJS is approved, right? So I think
correct, exactly.
So I think that's another consideration in terms of what paths do we have for status for both of them.
Right, and that's exactly, that's the case example that I had where the SIJS 485 ends up getting approved. So now the child is a LPR, and number 1 cannot help mom, but also number 2 is an LPR, so is not also going to be seeking a non-immigrant visa at that point. So very, very good point, Kelly.
All right, we have this next case. Gina came to the United States EWI in 2017 because her boyfriend was in the United States. Her boyfriend was physically and sexually abusive and forced her to work at his uncle's restaurants and would take her pay. You decide to apply for a T visa, and you get an RFE saying what Gina endured was domestic violence and not trafficking. So I think we have a poll here for this next slide. How do you respond? They're right. A U visa would be a better option. Would you respond to the RFE that focus on the elements of trafficking? Force, fraud, coercion. Would you do something else? Would you refer the case to Laura and then go and get lunch? Which is always my other option. It's just I would refer all my cases to you, Laura.
Unless
okay,
I'm out to lunch first.
Right? Okay. So other options is to file a U and a T, right? If they're eligible for both, then why not try to to file both? We have, we're not making the very good point that the wait for T visas is shorter than the wait for U visas. I think it is still in that maybe 18 to 24 month time frame. And so Deepa, because she's very diligent, would file for both. And just have that in the back pocket as well in case there is issues proving the proving the severe form of trafficking definition. Okay, that's very good. You're very diligent advocates. But I think this is a trend that we are seeing in the T visa context, especially whether or not when the trafficker is also an intimate partner, that there seems to be more RFEs and more issues of conflating domestic violence and trafficking issues. And so I do want to take a minute to talk about that. So you can go to the next slide. So I think we need to think about, the elements of trafficking. Is there any fact or any, excuse me, details about a grooming process? I think this is particularly important where you have maybe someone who's a teenager or another vulnerable adult thinking about, what were the steps, and was there any kind of manipulation to kind of gain a person's trust because there was an underlying intent for exploitation, for the trafficking. So I think thinking about that grooming process in terms of, were they particularly targeted? What was done to kind of do that initial trust and information, gaining that trust? Was there kind of an isolation? Were they kind of isolated from other friends and family members? So I think particularly in the trafficking context, and there's a lot on this, is identifying whether or not there was any elements of that grooming process, kind of that trust building with the intent for exploitation. And I think it's also really important to kind of making sure that you're defining the relationship as a trafficking relationship and focusing on the details that go to the trafficking, that go to the force, to the fraud, to the coercion, and not so much focusing on any kind of romantic relationship, because you kind of want to highlight all the force, the fraud, the coercion, and the elements you need to prove in order to establish a T visa case, right? And so I think also any other third party, right? This was his uncle's restaurant. Was there anyone who worked there, who was a customer there, who could potentially corroborate the details in that story? And so I think it's really important to talk about, as Deepa mentioned, the end, right? What is the end? It is the force, fraud, coercion to get their labor. If there was any kind of sex trafficking or commercial sex trafficking, what was the end as well? So I think that we have seen this more and more coming up. So kind of focusing on the elements of the trafficking, I think, is critical. Kind of both not only, what was the harboring, what was the different elements, which is kind of the different components of it, which is of the means and the eventual end. Laura, do you have more to add on this, or does anyone who has seen this in their cases want to talk more about this?
I think you covered most of the, I think you covered all of the tips that I would say in really moving that focus and taking the focus away from the quote unquote relationship itself, because it seems like what you don't want to do is refer to the trafficker as their spouse, for example. We have a lot of situations where the person was trafficked, and yes, there was a marriage, but the person was not, in fact, intending or acting as their spouse, but rather their trafficker, again, focusing on the ends. So when you're describing the trafficker, maybe think of staying away from the word spouse, so that it takes the adjudicator out of that mode of normalizing the relationship and looking at it through that lens of it being a relationship that has some really bad aspects to it, that has domestic violence to it, or some other crime, but not trafficking. So I think that would be the only thing I would mention, and that has worked for attorneys to really kind of get that focus back.
Great. Now we're going to turn to everyone's favorite U visas. Laura?
Okay, we don't have a poll, so we'll just talk about this a little bit, because I think this has been a very common scenario as of late, and an issue for many attorneys. So you get a request for evidence. And in the request for evidence, they're asking for arrest records for your client. Your client had been arrested but never charged with shoplifting. You had disclosed the arrest on the I-918, and then you get the RFE asking for the police reports and relevant documents. You don't get an RFE for an I-192. So how do you frame this? And if you have an instance where you've had an RFE like this and you have had a successful practice on overcoming this RFE, please do include in the chat box what you did and why you think it worked. So we'll start with the fact that arrest records have been found by many courts to generally not be a reliable source of demonstrating what USCIS is trying to demonstrate, right? That this person is actually guilty of a crime, right? Or even if they weren't found guilty through a court of law, that perhaps they actually did commit the crime for which they have not been convicted. So you certainly don't want your client making any admissions, and you really want to focus on what USCIS is asking for. So they're asking for the arrest records and any relevant document, police reports, sorry, and any relevant documents related to that shoplifting charge. What do you submit? So if the courts are finding that arrest records are generally unreliable, if you get those police reports and you find that the information in there is extremely prejudicial to your client, it has information that is incorrect or turned out to be completely false, not related to your client, which is ultimately why they were never charged, etc. And you don't want to submit it just as is because you fear USCIS giving it a lot of weight, then consider whether or not you're going to submit it to begin with, right? If you don't submit it, are you being responsive to that request for evidence? And that's really where USCIS is going to come down on, is if you don't submit the arrest record, are you being responsive to their RFE? So is there other relevant documentation that you can submit, right? Maybe you had answered the question on the 918 briefly. Is there maybe a reason for you to submit a declaration from your client just addressing the arrest that would shed some light and some relevant background to the arrest that would maybe satisfy the request for evidence in showing that, in fact, this didn't result in a conviction, so it should not be given much weight, and you certainly shouldn't have to submit a waiver for a ground of inadmissibility, right? So start there. If you are going to submit the police report because you figure, well, actually the police report is very cursory, it doesn't even have a lot of information or whatever, I would still urge you to make the arguments that police reports, especially in cases where it does not result in a charge being filed or a conviction, they have been seen as unreliable. And why they're unreliable, they're basically just someone's a third-hand account, right? Usually the police wouldn't have been present watching your client or watching the situation. They're called in after. And so what the police is writing down is just their own third-hand account, and it could be based on hearsay. It's not based on what would traditionally be considered good evidence in a court of law. And it's usually outside the court, if there was a charge, it's usually outside the record of conviction, which has been found to be reliable. So you want to put forth those arguments. What you also want to consider in terms of whether or not to submit a client declaration in explaining is, remember that your statements as an advocate are not evidence. So if there's something that your client can explain because your client was there and can more fully explain the circumstances, have that done through your client's own words rather than in your response to the RFE. We are seeing adjudicators point to that, right? The attorneys made this argument, but we will note that attorneys' arguments are not evidence and nothing else was submitted. So you do want to look for how best you can articulate the circumstances surrounding the charge, that your client actually did not shoplift, that your client was not found to have shoplifted and was therefore not charged, Get a police clearance letter showing that they weren't actually ever charged. Get court records that show no pending or adjudicated case has been found for your client. Go through the motions of finding other records that would show that your client doesn't have any criminal matter against them. And one thing that we will also forward, just as I'm thinking about it, we'll go ahead and forward. We have a couple of sample briefs that make the arguments on why the police reports on their own shouldn't be given much weight. And then we also have just some recent case law that you can use in making those arguments. If there's case law from your jurisdiction about that, don't assume that the adjudicator will go and look it up. If it's directly on point, just get a copy of that court case that says they shouldn't be giving much weight to the police report, and include that in there as well. Just make it as easy as possible for the adjudicator to find that you've submitted enough relevant evidence. Cecilia, do you have anything else to add on this?
I don't.
Okay, let's move on. Okay, so what about an inherited case? You inherit a U visa case that is still pending with the Vermont Service Center, and discover that the I-192 is incomplete. What are the best approaches for capturing missed grounds of inadmissibility while this is still pending? Okay, and Sarah, I do see your question where you say, would my response to the RFE be different if the RFE was actually on the I-192? So let's talk a little bit about this scenario, and then I'll tie it into Sarah's question. Okay, so if you have a U visa case that you've adopted, would you submit an amended I-192 with the missing information plus supplemental material? Would you just wait to see if there's an RFE? Is there something else that you would do in this type of situation? I'm going to give it just a couple more seconds if you could respond to the poll so that we can see what everybody's doing with pending I-192s where there's missing information. Okay, we can go ahead and close out the poll. So 100% of you would submit an amended I-192 with the missing information plus supplemental material to beef up that I-192. Yes, yay for everybody. There's a couple of reasons we would want to do that. Number one, obviously get your G28 in. Number two, correct the record as soon as possible. And the reason that is important is if USCIS doesn't know about this missing information, it is possible that USCIS would adjudicate the I-192 based on what was submitted and not issue a request for evidence because they don't have a reason to issue a request for evidence if that missing information was unknown. So yes, I agree with everybody in that you should probably submit the amended I-192 with the missing information plus supplemental material. I'm going to throw a wrench in it and say, what if you don't have all the supplemental material? Do you wait for the RFE? Do you go ahead and submit kind of a half amendment, right? You amend it, you provide what you have, and then hope to be able to supplement later. And I only throw the wrench in it with these facts because I've actually had this come up with one of, as a sample of one of our OVW grantees TA requests. That's exactly what happened is they found out, they felt like the case but has been pending since 2016, it's possible that USCIS will adjudicate, right? So they really wanted to go ahead and submit something now and supplement later. It's going to depend on your facts. So yes, let's go ahead and move on from this poll. Okay.
And Laura, there's no fee to amend it,
Yeah.
right?
I'm sorry?
There's no fee to amend your 192.
No, that's correct. That's a very good point. Yes, there is no fee to amend your I-192, and that's another reason why you would not submit a whole new I-192, because there's a fee, but also I think it will just, what it'll end up doing is just confusing the situation rather than clarifying it. There's already an I-192 pending, just go ahead and amend it. And so let's see. Is the catch-all language on the I-192 sufficient to waive all potential grounds of inadmissibility? And we'll let everybody vote on that.
And what we mean by that, I think it might be helpful to explain. Yeah. If you put something like, I am sorry for, or I regret, these are my inadmissibility grounds, and anything else that USCIS thinks might apply in my case. And so I think that is kind of that catch-all language thing. Even if it's not listed, if they know of something that I haven't mentioned, to go ahead and waive it anyway.
Right. So that's what we mean by catch-all language. And we'll go ahead and end the poll. And the majority is correct. No, you don't want to use catch-all language. If you're including the facts when you're answering the I-119, you're including facts that show and you are aware that your client is inadmissible, include all the grounds that you already know apply to your client. I know that sometimes attorneys will argue and say, well, hey, I don't want to do USCIS's job for them. They should be finding that there's a ground of inadmissibility that applies, and then my client should request that waiver. Now, technically, that is correct. Procedurally, USCIS has to make a finding of inadmissibility in order for your client to be able to include the waiver. But we are not in a situation where you are going to have an interview where you're going to have another option, right? These cases are decided based on what is filed. And so if we already know that your client is inadmissible, then you are going to submit the I-192 and not wait. And when you submit it, you're going to include exactly why you think they're inadmissible, and then, of course, why you think they qualify for a waiver based on public or national interest. And I should say that more specifically, the general catch-all of, please forgive anything that you might find, it's simply not working. USCIS is coming back and saying, what is the ground? These are the grounds that we find. You must specifically state what are the grounds of inadmissibility that you are asking to be waived. And then finally, just as a practical matter, it's best that you do include specifically what you want waived, because once the waiver is approved, then that is also helpful if later your client is applying for U adjustment. Remember that we know they first have to show that they were in valid U status, and valid U status includes that they were admissible, right, when it was approved. So if you have that waiver and you can show, look, I asked for all the grounds of inadmissibility to be waived, then it's just easier down the line to create that record that USCIS did consider the grounds of inadmissibility and did waive them. We have a question from Emily that asks, what if an I-192 is approved and they are ready to adjust status. And then they come and the past agency did not waive something on the initial U. How do you correct that? A new I-192 or just try to waive on the adjustment of status? Okay, so to start with, as we know, so at the U, if they are adjusting under INA 245M, which is the U adjustment of status, and that's what I'm going to assume, Emily, is that this is a U adjustment of status, then grounds of inadmissibility don't apply, except those grounds under INA 212A3, right? Some of those grounds do apply, but other than that, grounds of inadmissibility don't apply. So generally speaking, at the U adjustment of status phase, you're no longer asking for a waiver. So then do you correct the record? I think it's going to depend on the facts, Emily. So let's assume USCIS had all of the facts to find the client inadmissible on this particular ground that they didn't specifically waive, and you didn't ask for that specific waiver, but you included all the facts. I'm gonna take your scenario and I'm gonna add the inadmissibility ground because it's the one that we're seeing. And the one that we're seeing is smuggling. It was in the past that, oh, look at that, I guessed right. Emily says it is smuggling. Okay, smuggling of their children. And so this is one that we're seeing coming up because in the past, you know, the clients would submit enough evidence showing that, yes, they came in with their minor children. So mom and the children come in at the same time. Admit this on the I-918, admit this on the I-918A, even maybe admit it in the I-192 declaration that they include, but they don't specifically ask for a waiver on that ground. They ask for a waiver of other grounds of inadmissibility that may apply. And then it's coming back at adjustment of status. Hey, I see here that you actually smuggled your child in and you didn't ask. So the first thing you're going to do is you're going to want to make an argument that you in fact did disclose this and that in the waiver, inadmissibility waiver, USCIS made its own determination, either that A, she was not inadmissible for that ground, or B, she was inadmissible and they waived it. The fact of the matter is that USCIS in their approval notices doesn't tell us, and we can't read minds, right? So I think that's your best argument at the UAOS phase. If it's, I think where it gets trickier is if the facts weren't disclosed and the inadmissibility waiver wasn't requested. I think that gets a little trickier, and that's super case specific. So please talk to us when you're considering what to do at that phase. I think
right, and I think these cases are getting, harder and harder, especially because in the past we would just say you could do a non-pro-tunc from 192 to the initial filing, but I think that we, as Laura will attest, is becoming much more difficult of a process to do. So I think in these cases where you have an undisclosed ground of admissibility that you're just learning about at the time of adjustment, please reach out to us for technical assistance so we can kind of go into these details about, you know, what was in the application, what wasn't, because it's going to be case by case. And so I think that now, as a general matter, you know, and I think that this actually quite lovely transitions to our next webinar that we're going to be doing for you all, which is on Freedom of Information Act requests. What if you're approaching a deadline? What if your Sup B is going to expire or your derivative is going to age out? You need to get this thing in, but you don't have all the information that you would like for the case. You know, what are some strategies that you would do if you don't have a conviction record or something else that you would want to have available or to know in advance? Because sometimes you might not know a ground of inadmissibility exists until you do an FBI check, right? Or you get a FOIA back. There might be ways that you are approaching a deadline and don't have what you need. What are your strategies in these situations? There's 87 participants on this call, and I am sure that some of you have had this happen before. All right, let's give folks another second, and then we will think about it and talk it through with the strategies. Laura, has this happened to you before in a case?
Yes, it has. Yes,
right, and I think
has.
that Leah has the right idea. You file what you have available, and then you tell them that we are still awaiting information, the steps that you have taken to acquire that information, and when you would expect to have it available. I think that given the guidance that we have on RFEs and NOIVs and what might be considered to be initial evidence, that people are kind of nervous that they want everything and everything and everything. And, I don't think that's entirely unjustified, that you want an application to be as complete as possible. And so I think that, as Debbie mentioned, to let them know that you have that other things are going to be on their way, and that once you have a receipt notice, you can include the supplemental information with that receipt notice, which I would also scan and maybe let them know to the hotline that it's on their way, because the mailroom at USCIS just seems like a vast abyss. And so I think that making sure that the right information gets to the file is important. But it sounds like all of you are on the same page, that you just file what you have. If there's anything missing, just say what steps you are taking to get it and when you expect to have that available. I think it's just an expression of due diligence is really, I think, the best bet to do when you are, in a situation where you might not have everything that you want to file. So your U visa client submits an adjustment of status application, and Vermont Service Center has confirmed on the receipt date, but it's one day after the U visa status has ended. Okay? So you filed it before it expired, but your receipt notice doesn't reflect it. Is this going to be a problem for you? What do y'all think? Yes, no, maybe we need to do something to make sure everything is copacetic.
Okay, can I answer? Me?
Yes. Okay, so folks think that it is a problem. Laura, what do you think?
I agree with those folks. It will be a problem, and we really need to get our ducks in a row to show that you did file on time. And the reason it's a problem is because, as we all know, at the time of filing for adjustment, your client has to be in U status.
Right. So I think, we have taking a look at the regs. I have my 8 CFR right here, and I would take a look at the citation because it's going to be considered to be received and records the receipt date as the actual date of receipt at the location. So whether electronically or on paper. So I think that is really important to remember, is that, if, FedEx or UPS, says that it landed in Vermont, before the U visa actually expired, but the receipt note says something different, to request immediately for an adjustment of that receipt notice, right? If you have the proof that it arrived, which is a different scenario, is that maybe there was a freak storm or something happened with the mail and it actually did not arrive on the, if it arrived late and now your client is out of status, which is a different situation, right? So if you're experiencing where the actual date of receipt does not match what is on your receipt notice, and that would impact your client's status, contact ASISTA for help, and we can try to do some liaison work or technical assistance to help get everything clarified.
Yeah, and I will say, yes, definitely do contact us, but at the same time, send an email to the Vermont Service Center hotline with your G28 and your proof that Vermont got it on time. We have seen
with your FedEx.
yes, exactly, with your FedEx receipt notification showing got it on time. We have seen recently a few of these types of scenarios, and in some cases, just contacting Vermont has been enough. In other cases, we have had to intervene. But certainly, that's something that you want to do right away, is prove to them that the actual date was within the while they were still in U visa status. What if, as Cecilia said, there's a freak storm, and through no fault of your client, the U visa expires, and then FedEx delivers it, let's say, a day after? Not your client's fault, but also not USCIS's fault. What do you think, Cecilia?
I think you still probably have to 539 it at that point, you know, because it just, I think, to cover your bases and make sure that your client is safe, and I think that this can be based on the exceptional circumstances, right? That this is just outside of everybody's control, and they shouldn't approach it to the date that it should have been received.
Yeah, and so a couple of things, right? Since it's a U adjustment, if you filed I-539 non-protunc, absolutely, you want to get your client back in status. But at the same time, is that going to keep USCIS from issuing an NTA if your status has expired and you don't have it pending? So the possibility is file an I-290B motion to reconsider on that I-485 that gets denied because it was late. And basically in your reconsideration, everything that Cecilia just said, not your fault, not USCIS's fault, but you survivor should not be the one who suffers, based on FedEx or the weather, right? Okay, I think we should move on to the next.
Yes, we have 6 minutes for this very complex question. It's your last one. Thank you all for hanging in there for 2 hours. All right.
Okay, so denials. You represent a U visa holder and her 3 children. Her U visa was denied because of a discretionary denial of her I-192. You believe this is an error and you want to file an appeal. What do you appeal? So do you appeal the I-918 denial? Do you appeal the I-192 denial, or both? And we'll just give it a few more seconds since we're down to minutes. And okay, let's go ahead and close out our poll. All right, so the majority say both. File an I-192, I'm sorry, an I-290B appeal for both the I-918 and the I-192. So let's talk about that first, since that was what the majority said. So the I-918 denial was based on the I-192 denial. That's the only reason. So we are assuming all other requirements of the U visa of the I-918 were demonstrated. Because the denial is based on the I-190, because the I-918 denial is based on the I-192 denial, yes, you want to file an I-290B for the I-192 because you think that there is an error. But remember, discretionary decisions cannot be appealed unless you can show, so what you want to show is that there was an error of fact or law, and that is why the AAO should accept the I-290B as an appeal. If not, if it's just discretion, right? You're saying they didn't weigh the discretion properly. Instead of they got the facts wrong, they got the law wrong, right? They didn't, instead it's just completely on discretion. They say you submitted XYZ, but we find XYZ is not enough to merit a favorable exercise of discretion. If that's the only reason, then typically speaking, the I-290B would be either a motion to reopen or a motion to reconsider rather than an appeal. And what do you do about your I-918? Well, because of the risk of the NTA, I would say, yeah, you are still going to submit your I-290B as an appeal for the I-918 so that you don't get an NTA, and that you demonstrate what was the error of fact or law, or was it perhaps that the ground of inadmissibility that they refused to waive actually didn't apply? You know, make all those arguments. And so now we're looking at our best practices. So the I-290B should be based on the form denied on its merits. Make sure that you file the instructions correctly. There have been changes recently, so that's why we pointed this out. I know that it seems very obvious. Of course, you want to file where it's appropriate, but what's happened is sometimes the filing location of the Form I-290B on the USCIS website is different from the filing location that's included on the denial notice. File where it's listed on the denial notice. We've been in touch with USCIS on this particular issue, and the best bet is to file exactly where the denial notice tells you to file the I-290B, and if you have a problem with that, contact us immediately. I-290B, you can only include one receipt number. Does that mean that you're only asking them to reopen, for example, or appeal just one of the forms? And I would argue not necessarily, okay? USCIS has taken the position you can only check one box, right? And it's on the, they say that it's USCIS policy. Technically, I haven't seen that policy, but in any event, they say you can only include one receipt number on the I-290B. And they will either deny or kick it back and say, we don't know what you're actually appealing. So it is best to include just one on the form itself. However, if you are appealing the I-918, remember that the I-192 is an ancillary form to the I-918. And what I mean by that is the I-192 cannot be filed by itself. It has to have a basis for it, a reason for it to be filed. So include the I-918 receipt number on the I-290B, but in your letter, indicate when you're asking for what relief you're seeking, indicate that you would like for the appeal to be sustained, for the I-918 to be approved, and all other ancillary forms be reopened and approved as well. And at that point, you can include the various receipt numbers. So on your letter, not necessarily on the form itself. And then finally, every derivative needs to have their own I-290B. It seems ridiculous since the I-918A is technically ancillary to the I-918, meaning you can't just file a standalone I-918A. Unfortunately, what we're seeing is that because the derivative now no longer has a pending application, if once the appeal deadline is passed, we are seeing NTAs being issued to derivatives who no longer have a pending I-918A. So best practice is to submit the I-290B for the derivatives as well. That is all I have on that. Unfortunately,
and if I could just say
something,
just to be clarified, right? So I think it's important.
Oh,
we have that first point. I think is a little bit confusing, right? Denied on the merits, right? Because if you have a discretionary denial of a 192, that can't be appealed to the AAO, right? And so you're looking into kind of the motion to reopen or other kind of type of administrative review. So if you have any questions about this in terms of what can I appeal and what can I only do a motion to reopen or reconsider, to contact us and we can help you walk through it in less than the 2 minutes it's taking us to do so on the webinar. So again, I think that there's a lot of nuance, particularly between what is reviewable on the 918 and the 192, what can be appealed, what is only available for a motion. And so if you have any question about that, then to please let us know. But these receipt numbers is something that we are seeing become rejected because people are listing more than one. And so, but again, I think that there's important to do it, or maybe ways to frame it so people are, that USCIS are on notice that there are other ancillary forms that are involved. Is there more that you would add on this? I think this is a confusing slide. We wanted to put it in there because it's an issue that you raised, and if it's something that you are facing, to reach out to us for additional assistance. Because it has been all over.
I think that's the only thing I wanted to end with, because Leah has some good questions on that. You know, some people have tried this, that, or the other in terms of that one receipt number. It is all over the place. That's the bottom line. And that's what's been so frustrating about this. And the reason it's worked in some cases and not all, what we've found, I mean, we don't know for sure if this is the reason, but in those cases that have a strong basis for appeal on the merits, in other words, there's clearly they misread the facts or applied someone else's facts or something, in those cases, they've reopened all of them. And so that's why it's kind of been all over the place, and it's best to do a case-by-case assessment of what your strongest approach will be. And if you need help with that, of course, contact us.
Right.
I think we do need to wrap it up.
Yes, Elizabeth has a great idea of maybe another webinar specifically on what is motions to reopen, appeals, the nuances in the U visa context. I think that is an excellent idea, and one that we can look into.
Yes.
Or send you a link to one that we did before.
Exactly, that's what I was going to say. We do have ones that we've done prior, so you're welcome to look at those, and also check out our website for additional materials on that.
Well, thank you all for sticking with us for these last 2 hours. Please do reach out to us. Our direct emails are here. We are happy to hear from you and go into further detail. For individual case assistance, you have the link there, and I wish you all a great rest of your day. Thank you so much to you all.